everyone, and we are going to go over Ripper v. Simmons, which was ruled upon in 2005, here in our micro lecture. This is the really cool thing about the Supreme Court. One of many really cool things is that once an issue is ruled upon, it's the law of the land. And it can be the law of the land forever or until the issue is reheard by the court. So the law of the land on executions for juvenile crimes, juvenile capital crimes committed at the ages of 16 and 17, as we know, was determined by Stanford v. Kentucky, in which case the court said it is not a violation of the Eighth Amendment constitutional right against cruel and unusual punishment. It's okay to do that. We can apply death sentences to juveniles who are convicted, wave into an adult court, and convicted of capital murder. And that was the law of the land for about 40 years until Ripper v. Simmons came along. And let's go through the background. So in 1993, there was a guy named Christopher Simmons. He was 17 years old, and he devised a plan to burglarize a woman's home and murder her. He asked two of his friends to join him. Luckily, one of them exercised better judgment and backed out of the plan before it happened. The other went along. And Simmons and the friend ultimately broke into the victim's home. They bound her with duct tape. They drove her to a bridge, and they threw her over the bridge into the river below. Ultimately, she was still alive for this process, and she died of drowning. Simmons was arrested. He had been bragging about his actions after the fact, so he was arrested, and he openly confessed to the police. He also provided a videotaped reenactment of his actions. There was evidence that Simmons had, this was premeditated. He had pre-planned it before he did it. And like I said, he bragged about it afterwards. The jury found Simmons guilty and recommended the death penalty, in which the court agreed with and imposed. So Simmons was given a death penalty for a capital murder that he committed while a juvenile at the age of 17, which at this stage of the game, fully constitutional, fully in line with the findings in Stanford v. Kentucky. However, Simmons' attorney had appealed all the way to the Supreme Court. And they didn't appeal on the basis of cruel and unusual punishment violations based on age or based on the status as a juvenile. They based it on Atkins v. Virginia. And they argued, hey, the court recently said that people who are cognitively disabled, people who do not have full cognitive function, cannot be executed at any age, adult, juvenile, or other, can't for crimes of any age. You can't do it. It's not constitutional. It violates the Eighth Amendment right against cruel and unusual punishment to execute somebody for a crime in which they didn't have the full mental capacity of decision making to draw upon to decide whether or not to do it. And Simmons' attorney says, it's not any different here. If we can look at somebody who has a low IQ and they don't have full cognitive capacity and we can't hold them accountable at the capital crime level, then we should be extending that same privilege to juveniles. Why? Because juveniles' brains aren't done fully growing until 23 to 25. Biology tells us that. Hard science tells us the brain, in particular the frontal lobes, are still developing. They're not done developing. And Simmons' attorney basically said, isn't that the same thing? Right? I mean, it's, regardless of the kid's IQ being low or high, their cognitive capacity isn't yet done growing. And isn't this the argument that Atkins made, that if somebody doesn't have the cognitive capacity, they don't have full capacity on which to make decisions, therefore we can't execute them? Again, it's not saying Simmons gets to go home, but is it a violation? Is it cruel and unusual if somebody isn't done mentally growing, literally their brain growth isn't done? Is it a violation of the Eighth Amendment prohibition against cruel and unusual punishment to execute them? And this is where the Supreme Court gets interesting, because we're fast forwarding a good 35 years from Stanford. And at this point, there are different justices on the court. And they rule differently. And they say, yes, it is a violation of Eighth Amendment cruel and unusual punishment. You can't execute juveniles for capital murder that was committed before they're done growing, before they have the full cognitive capacity of a fully grown brain to make those decisions. Now, they took this argument a little bit further. So they also argued that national consensus, 35, 40 years after Stanford, basically indicates that executions for juvenile offenders are very rare. Yes, it's on the books. It's been on the books since Stanford, but it's hardly ever used. right? Which gets back to those evolving standards of decency that we talked about in Stanford v. Kentucky. It looks like since Stanford, the United States has evolved the standards of decency away from this practice, that we're no longer comfortable with it. If we were comfortable with it as a society, we would make more active use of it. And the fact that we haven't indicates we're no longer comfortable with it. They also argued that there's three major differences between a juvenile offender and an adult offender, and that because of these three major differences, juveniles should be treated differently with regards to the ultimate punishment of execution. And the first one is that juveniles simply haven't met their full maturity yet. And they won't until they're done growing, until their brains are done growing, and until they stop being juveniles. The second is that juveniles are more susceptible to negative influence, peers, and overall manipulation, which means that not all of their decisions are 100% theirs, right? Their decisions are influenced and more influenceable because they're juveniles, because they're not adults, because they don't have all of that growth and development. And finally, the third argument is that a juvenile's character is not fully formed. It's not as fully formed as an adult. So these are all three arguments that work in tandem with that overarching argument that juveniles, their brain isn't fully done growing, they're not done fully growing and developing as a human, and therefore they are at some level of diminished capacity, and therefore we shouldn't apply death sentences. Ultimately, again, the goal of retribution is not the focus here, or it shouldn't be the focus. And certainly there was the citation that, or the point that they made that the United States is the only country in the world that would give official sanction to the execution of juveniles or for crimes committed while they were a juvenile. International law rejects that notion. Most first world countries reject that notion. We were in the minority on a global scale, so it was just more justification for this court to say, we are striking down Stanford v. Kentucky and the ruling in Stanford. Yes, it was ruled upon in the late 70s, early 80s that you could do this. You could execute juveniles for crimes committed. But fast forward to 2005, we're a different country. Our standards of decency have evolved and changed. And as a country, we're no longer comfortable with it. Not to mention our science has gotten better. We know more about adolescent growth and development, in particular, adolescent brain growth and development. We know it's not done growing until about 25. So it's not fair for us to hold them accountable to the level of execution. Can we hold them accountable? Of course we can hold them accountable, but not to execution. And certainly we can't have one standard in Atkins and not uphold the same standard in Roper v. Simmons. The court can't contradict itself that way. If diminished capacity in Atkins v. Virginia is a reason that we have to stop using the death penalty, then therefore that argument sits with juveniles as well, who aren't done growing and developing. And as such, as of today, as of 2005, and currently as of today, it is now a violation of the Eighth Amendment cruel and unusual punishment doctrine to apply a death penalty for anyone who's committed capital murder under the age of 18.